Hey everybody, Tom Kherkher here. Welcome to the third episode of Counsel Table. In today's episode, we're going to be talking about ad litem work. I'm here with Shara Gilbert and Jose Lopez. Of course, Omar and Will are with me. The only thing that I will note is we built the set for 4 people. We have 5 today. So Will and I are going to be sharing a microphone. With that said, I'm going to pass my microphone over to Will, and let's get started.
Yeah, let's get started. So you guys are both very skilled trial lawyers, accomplished trial lawyers, also mediators, and we can talk about those issues. Skilled mediators. But I think there's a not an unfortunate lack of understanding as to what you do as ad litems, but it is again, a simple protect the kid concept, but the reality is that creates a lot of problems, a lot of issues, a lot of lack of understanding. So we wanted to have you guys in a very wonky legal show kind of explain to our audience what life is like as an ad litem, the importance of it, the ethics of it, and things like that. And we'll just free flow and spit it out.
First, we want to introduce yourselves for the people that don't know you, but I'm pretty sure if we're talking to Houston legal community, you guys are pretty well known. So, but go ahead, Shara, you want to start?
Sure, I'm Shara Gilbert. I have been licensed to practice law for a little over 15 years. I cut my teeth trying car accident cases as an insurance defense attorney for Farmers Insurance. A lot of people don't know that I did plaintiff's work before I did insurance defense, but where people started to know me and know my reputation was through trial work, trying cases. In fact, Jose and I met when I tried my very first case in a court of record, and Jose was an ad litem in the case, which is a kind of a funny full circle moment because we're here doing a podcast about said topic. I'm board certified in personal injury trial law. I was lucky enough to get into the ABOTA organization in 2021, and so I began my mediation practice in 2019. I've been officing with Jose since then. Before that, I would mediate with Jose, and I thought, man, I could do a much better job than him, so let me come office with him and tell him how to do it. Just kidding. I'm happy to be here. I conduct mediations in English and Spanish, and I'm often selected to be an ad litem in cases by judges and or asked to be appointed because I am bilingual and have that experience. So thank you for having me on your show.
Of course.
Great. Can I ask a very basic question in case anybody listening is just a new lawyer or wanting to get into the legal field? What is an ad litem?
Sure. An ad litem is a court-appointed representative of the court. A judge will appoint an ad litem in various situations. In the most simple situation, it's when you have a minor, right? You have a person who is not of age to make decisions for themselves. I have also been appointed as an ad litem for an incapacitated adult. So in those situations, the court finds it necessary to have a person who is not affiliated with the case because there is a conflict of interest that exists between the parent and the minor and or the person who is incapacitated. It is of importance for the judge to appoint someone who can look at the case from a fresh lens to make sure that that person is getting a fair shake.
Now, is it always
Well, hold on. To add on to that, there's a guardian ad litem and an attorney ad litem.
That's true, yeah.
And so, I'm sorry, go ahead.
No, go ahead.
You need to introduce
Yeah, I was like, who are you?
Oh, I am. I am who I am. Jose Lopez. I've been a lawyer now for about since '87. I've also been a judge in the city of Houston, also tax master in Harris County. Been a mediator for probably around 25 years. I did a lot of litigation. I've done insurance defense work. That's how I cut my teeth. I've done a lot of plaintiffs work, worked over at some plaintiffs firms, opened up my own shop about 25 years ago. Have done a lot of work basically with personal injury and some small commercial cases. Right now, my mediation practice is good, working with Shara. Do mediations in Spanish and in English.
And your daughter recently joined the team, right?
Yes, she did. As a matter of fact, she's very particular about this. I don't work for my dad. I work at his office and I pay him rent.
Correct. She joined the team of that Washington Square or whatever.
It's the Washington Mediation Center.
Thank
you very much.
Center. Yeah.
Thank you.
There's a lot of good people over there.
So carrying on with regard to the ad litems, there's 2 different types of ad litems. Guardian ad litem, which protects minors, and attorney ad litems. But today's purpose, we're only talking about guardian ad litems. The distinguishing factor about attorney ad litems is they're appointed for people who don't have a lawyer. Sometimes when you have a next friend who has not hired a lawyer, the judge will appoint an attorney to represent that next friend. Because, as you know, in the state of Texas, a person cannot represent anybody else unless they're a lawyer.
And so here's one thing I've been practicing 12, 13 years now. The as next friend. What does that really mean? Like I've always just put it because that's what we've had to put.
It's in the contract.
Yeah,
You're signing as next friend if it's applicable.
Yeah, it's A&F. As next friend. What is that to everyone here? What does that really mean? Just
As next friend, it just means that you are acting as the next friend of the minor. That's all.
Yeah.
That's all it means. It's not anything terribly difficult to understand.
just legal nomenclature.
It's a legal nomenclature.
My
yeah.
understanding is, it's not your next of kin, but it's the person who has probably more control over this person than anybody else. For example, like a guardian, like someone that lives with a minor, or maybe someone that has power of attorney, right? And so that's probably who the most appropriate person is. It's next of friend.
Yeah.
So
That helps because sometimes we do it because that's the form we had, and we're like, I think this
copy
is right.
and paste, right?
Yes.
Yeah.
So,
Which sometimes will lead you into more trouble than help.
yeah.
So, but yeah, let's. I want to dig in. I know Will has some pointed questions here.
Well, not really pointed, but there's the as next friend. And an example, I'm a child, I'm injured in an incident. My mother or father might appear on my behalf as that minor child as next friend. And they have a job to do, not just as parent, but in this legal environment. But ultimately, when it comes down to approval of a settlement or the best interest of the child, at some point, the guardian ad litem, not the attorney ad litem, the
Correct.
guardian ad litem concept presents itself. What does it mean? How does it happen?
Well,
open-ended.
Well, with regard to the rules, if you look at the rules, it's very specific. The rule says that a guardian ad litem is only there to tell the judge whether or not the settlement is a good settlement or a bad settlement. Before the rules changed, I think it was in 91. I want to say it was 94. A guardian ad litem basically took over the role of the next friend and basically controlled the case. He could talk about settlement. He could negotiate settlements. He or she could talk about negotiate liens and so forth. That changed. There was a case down in the Valley which changed the role of an ad litem. At that point, now, if you look at the rules, the only thing the rule says about a guardian ad litem is all we do is recommend to the court whether or not a settlement is a good settlement or a bad settlement. There's a thing in the community right now where you have a guardian ad litem. I'll have a lot of lawyers say, hey, negotiate the lien. I can't do that. Because a guardian ad litem has quasi-judicial immunity. And the quasi-judicial immunity is based on the fact that we are limited as to what we can do. Once we go outside the scope of that, our immunity gets lost. When we talk about annuities, when we talk about funding, we're asked about it, but I am not the person that's going to say financially this is a good annuity. I'll suggest it, but I'll leave it at the plaintiff's lawyer as well as the next friend to pick the annuity.
Okay, hold on. So if there's a approval of a settlement,
right?
What about when there's negotiations of a settlement? Is it too premature at that point to say this is a good deal?
Well, remember, my job as a guardian ad litem is to tell the court whether or not the settlement is a good settlement, it's a bad settlement. You will call me in, or the court will appoint me. I would then get a call from the plaintiffs who are saying, hey, look, we're trying to get the case settled. We think this is a good case. We want to get it settled. We want to get it approved. Can you talk to the next friend more about it? I'll talk to the next friend. If I think it's a good settlement, I'll say, yeah, this is a good settlement.
And that requires us to make a request to appoint
yes.
an ad litem.
Yes.
Prior.
Yes.
So
That's
hypothetically, if I have a case or if I'm involved in a case, and it is purely hypothetical, where maybe the parents as next friend have maybe a financial conflict with the child.
Yep.
I think that, hey, this is the child's injury, the child's money. I got a bit of a conflict because I represent the kid to the extent I can, I guess,
Yep.
through the mom, because legally they can't contract with me or my law firm.
Correct.
I'm dealing with the parents, but I think, man, there's a problem here. Is it something then, a mechanism that allows me to go to the court, appoint an ad litem to help me deal with the conflict associated with that?
I would say yes.
Yeah, some judges do, some judges don't. Some judges require that we already have a settlement in place.
That was my question.
Yeah, that settlement in place. And once you get the settlement in place, you get the guardian ad litem involved.
And I've been on the reverse, which is there is no settlement, and the judges appointed an ad litem because they see these issues, right?
Yes.
The parties have brought this to the attention of the judge and said, you know what, Judge, I really think we need an ad litem, and the judge says, yes, I agree, and then here I am.
Is there, again, I think the world knows, and you guys definitely know, I'm a former defense lawyer that now does plaintiff's work exclusively. Don't call for any defense work. Had to turn 2 phone calls down this week. I don't do that anymore. He doesn't work here anymore. I got my TTLA tattoo now.
There you go. You're a lifer now. It's been branded.
But if, as a defendant, if I thought, hey, maybe I got some signals from the plaintiff's counsel like, hey, I'm in a spot here. Can a defense lawyer go down and seek appointment of a guardian ad litem in the scenario that would allow a court to say, look, there's some opportunities to settle this case?
Yes.
Yes,
You can do that.
by way of a status conference, right? So you can bring this to the attention of the judge, and I think it's, hey, let me send you some smoke signals. I think this is what's going on, and I think most judges down at the courthouse will be able to sniff out that there's an issue, and then henceforth.
And I think the reason that is when you have a settlement on the table, plaintiff's counsel and defense counsel are thinking, yeah, this is a good settlement. Next friend has an issue. The conflict, that's where the conflict arises. Right. Because the next friend does not like the settlement. The next friend wants to keep the child in the lawsuit because sometimes people think that they're not getting enough money for their kids. And so you go in as a guardian ad litem, you take a look at the case, and you tell, look, this is a good settlement for your child. You have to explain to the next friend what the good things and bad things are going to happen at the courthouse. Sometimes it's a good oftentimes it is a good thing.
I wanted to piggyback on your question about ad litem and how you get appointed. You asked about that, right? And how the process. What I have found typically is you have to actually request for the court to put you on their Rolodex of ad litems, right? And so that requires probably getting in front of the judge by way of some sort of letter indicating that you have an interest, indicating that you've met the requirements. Some judges require for you to take an ad litem course. Mm-hmm. I have actually done that. And I think that certain judges down at the Harris County Courthouse were requiring you to take, and I think it was an implicit bias course to some degree. Having another language under your belt, like Spanish, like for both Jose and I, is certainly crucial, because we have so many plaintiffs that are Spanish speaking, and the communication barrier is so significant. So you need an ad litem that probably speaks the same language as your next of friend, right? So they can understand the legalities of the situation. And so you can't just specifically ask for the judge to put you as an ad litem in a case. Now, I have seen that. I've seen people put my name and Jose's name. Sometimes the judges are comfortable with that. I've also seen my name being scratched out because the judge doesn't want there to be some sort of weirdness going on.
It's called collusion.
Collusion, right. I was going to use the word collusion, but
I just
weirdness
want to help you out
better.
there. That's all. Don't worry about it. I'll help you out.
Right. And so I think the judges feel like it's better that they just select from the list and where you're at on the wheel. But that's how you get your name out there, right? And then obviously to keep your name on the ad litem list, you need to be a good ad litem. You need to review the case. You need to meet with the parties. And you need to move the case in an expeditious manner, because there's so many ad litems that don't do anything. Yeah. And they sit around. And I will tell you why that's a problem is because you have money that's not accruing interest on behalf of the minor. But more importantly, you have parents who don't have funds being released to them because they haven't had their day in front of the judge to give the blessing that this is enough money for the minor.
And going on top of that, with regard to the experience, you have a lot of young lawyers, 3 or 4 year lawyers who are coming in trying to be an ad litem, trying to get a quick buck on these cases. They really don't know how to proceed. We're available to talk. I mean, I've even told any young lawyer, if you get appointed as an ad litem, you want to come talk to me, I'll show you. I've got an outline. We can go over the questions. And I've seen many a time, and I'm sure you guys have seen some ad litems go down there, and they don't have a clue about it. I know when an ad litem doesn't really know what he's doing or she's doing is when the judge asks who's going to present the case. And it's usually the plaintiff's lawyer or sometimes the plaintiff. At that point, they got an issue with the guardian ad litem.
I really feel that the prove-up should be done by the ad litem because that's probably the person that knows the most about the case. In fact, I tend to do the majority of the prove-up on all of my cases, and if I've left a question off, that's my fault. And typically, if there are no additional questions, I know I've done my job successfully.
At the risk of sounding crass, if there's any lawyers listening to this who are interested in getting into ad litem work, how does an ad litem get paid, and where does that money come from?
Certainly. And so that should specifically be the carrier, right? I'm using a car accident as an example, but there's all kinds of cases that could require ad litem work. But the simple answer is the defendant. And the reason why is because it's the defendant that benefits from having a release, right, and a record at the end of the day. Because we all know that the statute of limitations, right, for minors, 2 years after the age of 18, right? And so what you're trying to do is you're trying to alleviate any additional claims later on. So the benefit therein lies for the defense to receive the closure of this case, a record that seals the deal so that later on they don't have some sort of claim that pops up, oh, well, I've got TBI, traumatic brain injury as a result of this incident, and I've continued to have headaches, so and so. I mean, if you don't have a release and you don't have a record, you leave loose ends out there. So I've always felt that if it's in the defendant's best interest, they should be paying for it, right?
And there's been times where you've seen where maybe when you're a guardian ad litem for an incapacitated person that they may share the cost because there's a lot more that goes into that, I believe, than a minor.
Yeah. It really just depends on the case itself. And sometimes there are discussions before you even get to that point about who's paying the ad litem fees. Sometimes the parties agree to split the fees. It really it's a case-by-case scenario. But if we're talking about a situation where there's insurance involved, and I specifically say minors, remember, the benefit therein lies on the defense, right? They're getting the benefit of having that record done and having the case, coming to an end and closing that chapter.
Yeah, it's a commercial lines policy. More often than not, it's going to be cost outside the indemnity limit. So it's going to be a defense cost and the defense obligation, not eroding the indemnity limit.
Yeah,
E&O policy, or what's the scenario of a wasting policy really outside GL? Not really often. Professional lines.
It's a cost of doing business. It has nothing to do with what is in the policy.
Yeah.
Right.
Yeah.
And I used to get asked,
That's correct.
As a defense lawyer, I was always asked, hey, we have to have an ad litem. Why? Well, because it needs to be proved up.
Yeah.
So we're going to talk about proved up. We use that word, but I'm going to try to explain that a bit.
Yes.
But then it was, well, what's the rate? Is it commensurate on the type of case?
It's no. Myself, I always keep an hourly rate. My hourly rate's either $450 to $500, and so I keep an hourly rate. I keep a timesheet as to what I'm spending on each of these files. Most ad litems should do that. If you're not doing it, you're going to get grilled by the defense counsel all the time. I've seen ad litems go down there on a $10,000 case where they have $3,500 in attorney's fees or ad litem fees. I'm going, how'd you get that far? There's only so much time and hours you can put on a file, especially a small claim. I've seen guardian ad litems not be appointed again because of their fees and criticized about appointed fees. And I've always told ad litems, keep an hourly billing record on your case.
Because the defense has a right to call you and cross-examine you to prove up your fee if it can't be agreed to in advance.
You want to try to avoid that.
And you know how embarrassing that is? Sometimes.
If you didn't keep time, I'm sure it's really embarrassing.
You know how embarrassing it is sometimes for defense counsel. I've had defense counsel before where I have a fee and I'm going, okay, I'm gonna try to shave some of it off, and the defense counsel is on me going, well, now we want to prove up your fee.
Yeah.
I said, are you sure? And I said, yeah. So instead of them paying me $3,500, my fee's $5,000 on my sheet. And I said, okay, I want $5,000 now. I told you guys, beware what you ask for.
I think your bill for an ad litem work is commensurate with what the case entails and how much work you really do, right? If we're talking about a soft tissue injury, car accident case where the minor's getting less than $5,000, your fee probably shouldn't be significant in that case, right? And so, but not every case is apples to apples. In cases where I have to shop annuities, right? Or, for example, I have to meet with very difficult next of friends, or I have to go back and I have to renegotiate the settlement because I just don't think it's going to get blessed by the judge. Those are cases where I'm doing more work, and I feel like my rate is, it's satisfactory for the work that I'm putting in the file. But more importantly, I think that also goes to whether or not you have a good ad litem who's doing the work, who's getting the file moved, right? If you're sitting around and just billing, and you've been sitting on the file for 6 months, I think the other side's going to have a problem with a really large fee if you really haven't done much and you've been dragging your fee, right? And so you have to be mindful about that. I often teeter between a certain amount. In very large commercial cases where we're talking about significant amounts of money with annuities and annuities that overlap one another and things like that, and liens, and just voluminous amounts of records, and I have to go through cost expenses, allocations of cost expenses, my ad litem fee is a lot more. But in cases that are smaller, I keep my ad litem fees relatively low just because I just don't think it's fair. So, and I don't want to be called out for for abusing, so to speak, the appointment, right? So.
And you mentioned one thing there that I wanted to ask you about when you go in and you think the settlement might be too low for what the minor has experienced. You know, I'm sure that's happened.
A lot, yes.
What do you do in that situation, and is it difficult?
It's always difficult because you're telling people that you didn't do your job right. on both sides, but not in those words.
Well, yeah, when you go back and we have to reevaluate the file. You look at it and go, well, how much is the minor getting? For the injury and for the amount of time spent on it, I don't think it's much. I've got one right now where I have a tender of a certain policy, but there's a UIM policy up there. No one's ever looked at it.
Exactly. Or PIP. Where's the PIP?
Yeah, and so
Personal injury protection benefits for those that don't know.
I've had a pro se person there, and I'm like, I got to get UM on the. You got UM? Yes. So then I have to go back to the court. In my opinion, I go back to the court and said, this is a good settlement, but there's a UM policy. I'd like for you to go ahead and appoint an attorney ad litem.
Yeah.
The attorney ad litem is then appointed for the mom, and that's when the attorney ad litem goes after the UM policy.
I've had it where, well, thanks, Jose, for putting yourself on silent.
That's all right. No,
To be fair, there is like a giant storm and flooding going on, so I'll give you benefit. That's why I had to check my phone.
That was it. That was the emergency.
The only
Exactly.
thing Jose is flooding in his tequila most days. Anyway, I digress.
You can keep that in. That's
What
fine.
I was going to say about telling people how to do their jobs, what I always am mindful about is if I go and get more money for this kid, you are not taking any additional
You got
fees
it.
from that money.
Absolutely,
Like that is that
yeah.
kid's money, right? And so I oftentimes find cases being undersettled in pre-lit when parties file friendly suits and the lawyers have settled the case before there was any litigation, and I'll go through the file and I'll see herniated discs for a minor child, I'll see bruising, I'll see significant impingement, nerve root impingement, and I'll say, why did you settle this case for less than the medical? No judge is ever going to approve this. And back to the drawing board we go. And then I have to have that uncomfortable conversation with the defense side saying, oh, y'all thought you got away with this one, right? Well, here's the deal. It's not going to be blessed by me. It ain't going to be recommended to the judge. And no judge is going to sign off on this. So you go back to the well.
There's situations where it's minor only cases, and that's the only person participating in a settlement.
Correct.
And then you've got to go to plaintiff's lawyer and say, you got to go get more cash.
Yeah.
And you go
Right.
to the defense lawyer and say, you got to get more cash.
Yeah.
What happens if you don't get more cash? Goes to trial, there's no settlement.
Well,
Yeah.
what happens in those certain? It depends on the case itself. If I don't think if I can get more cash, and I'll tell the judge, I don't think it's a good settlement. I had one in front of. Can I say names in this thing?
Sure, absolutely.
I had one in front
Some
of.
will be guests soon.
I had one in front of Judge Wyman a long time ago, and they had settled the case. I didn't think it was a good settlement at all. And so judge looks at me, and the lawyers were forcing a minor settlement hearing. I already said, they asked me about it. I can't approve it. So the judge looks at me and goes, what do you think, Mr. Lopez? No. And he goes, well, I don't think we're going to approve it, are we? No. So then thereafter, we were able to get an extra $20,000 for the child, because I went back to the defendant and goes, it ain't going to be approved. You got the money to do it. We got to get it done. So we got an extra $20,000. We go in front of the judge again, and that's when I got in. That's when I got in hot water with the plaintiff's lawyer, because he wanted a fee off the extra $20,000. Said, you ain't going to get it. Why not? Because you didn't ask for it.
Didn't do the
I
work.
did. You didn't do the work for it. As a matter of fact, I even got a problem with your fee right now. So it happens.
Well, I'll go back to the fee deal.
Yes.
'Cause
I'm gonna put a pin in that.
Because that's big. But what about when you have, like, sometimes you have a collision between, there's a gross settlement, adults are involved, a minor gets a part, and you got to go say, look, Grandma, you getting too much. Mom, you're getting too much. Dad, you're getting too
The
much.
allocation just ain't mathing.
And you got to move
Yeah.
some money,
Yeah.
not so much in a gross sense,
Yeah.
but you got to move the allocation
distribution.
over.
It happens.
Because, again, being candid, there's probably some, I hate to say it, but there's a different fee percentage on the adult claim than there's a child's
Sure.
claim. And I would hope, and I know our friends and colleagues wouldn't say, I'm going to settle the case on the higher level because I get a better fee.
Right, you're getting
Y'all
your
seen that,
40%,
I bet.
Yes. Oh
Yeah.
yeah, we have.
We know. We've
have.
seen it all.
And we know when lawyers come in and their fee arrangement with the adults and the minors, and there's a disparity there, and we know why they're doing it. And so we have to be kind of cognizant of that.
So what I'll say is this, and this is me putting my mediator cap on, what I appreciate about what we do as mediators and the ad litems is we kind of see the full circle thing, right? And so when I'm mediating a case and there are minors involved and we've got, whatever pool of money, right? The first thing I'm thinking about, at least for the parties here, is whether this is going to pass the smell test for an ad litem, right? Because you have to think about those things.
What is the basic smell test? What are your 3 things that you're looking for?
Well, I mean, it depends on whether there's medical involved, because sometimes there's derivative claims, right? There's not necessarily a claim for bodily injury, but rather a derivative claim that stems from a next of friend, right? And so proportionality, but more importantly, again, whether or not the judge is going to look at the case, and they're going to want to know what the other parties settled for, and they're going to want to know if the settlement for the minor was proportionate for the minor as it relates to the other parties involved. And so as a mediator, I always think about that, and that's something we bring up. And I think that that's so important, because you don't want to set yourself up for disaster before you even get into the minor settle, or get into the appointment and the minor settlement hearing. You need to be talking about that with your mediator in mediation, if you are in mediation. And so the other thing that I'll say is you want to get out the way of the expenses. You want to talk about who's paying for the ad litem, who's paying for the translator fee, are we filing a friendly suit, things like that. I will tell you, I have mediated pre-lit claims oftentimes where they say, well, we don't even need an ad litem. We'll just, right? We'll just, we won't even file a friendly suit.
I got asked that question a bunch.
Yeah.
It's some myth in CLE done by insurance land somewhere. Well, it's less than $10,000. You don't need to have it proved up. My response was, one, that doesn't exist legally.
Yeah.
If you want to protect yourself, don't do a parental immunity release.
Exactly.
Pay the money, a few $1,000
the
to button
dollars.
up, not getting sued later.
Yeah, we don't mind on the plaintiff side, because we don't have to worry about it, but it's because it doesn't affect us.
Correct.
But at the end of the day, it's like you said, it's for the defense.
Do y'all recommend rates or percentage fee to the judge, or is it kind of off the record? Hey, you're going to have to knock your rate down a little bit.
Are you talking about the plaintiff's
plaintiff's lawyer
rates?
fee on the fee agreement with the kid?
Well, that's
such a hot topic.
Is it court?
It is, because where in the law does it say the judge has the authority to do that?
Right.
Does anybody know that?
No, and it always seems to be just standard now. But there are times where I think the 40% is well earned.
Yes.
We'll
Now,
go back to that.
Yeah. Well, with regard to the percentage, we'll talk about that, because I'll tell you how some lawyers have handled it. But with regard to how the judge is able to do that, I think the family code has that. That then family code has that they can control the percentage, but not down to the civil courts. And so it's just historically, rates are 33% for the kids, historically. Now, how you get 40%, I had a really, really good lawyer. He's passed away since then. It's been about 10 or 15 years ago. He showed me how he got his 40%. He did a great presentation in front of the judge. Showed him the case was a large case too. Showed what he did for the kid, what he did for the family, and how he got the settlement. And he was able to get he was not 40%, it was 45%. On the deal. Yeah.
I was an ad litem on a case that went up and down on appeal, and a lawyer had done a ton of work, obviously, more work than your average case, lots of expenses in the case, and he got his 45%. He earned it. He definitely did. I've had cases where the lawyers have been approved for 40%, and they've waived their expenses. And so the answer to that question is it really just depends on the case and how much work is involved, how many depositions. What the judge is going to ask you is, well, how many depositions did you take? Did you hire experts? Did the case go to mediation, right? Things like that. Like, what work did you really do that was legal work and lawyering to get you so we can say, okay, yeah, we bless the 40%.
Well, also as a guardian ad litem, I take a look. Sometimes you have cases that go in there, and all the lawyer's done is written a letter.
Yeah.
And that's all he's done. And he wants either 40%
on
or 35%.
a 30-60 policy. Yeah, you're not getting
But what if
40.
it's reputation-based? What if it's a big-ass case, and our friends in town who we know who they are, their letterhead commands premiums? Is there a difference there or not there?
At that point, I'm going to jump in on here, because I think if their reputation has done that, they're the ones that are normally agreeing to cut it down.
They are.
They got plenty of money anyway.
They are.
True.
Yeah, they are.
I think those are
They
the guys that are more like, we'll waive the expenses,
Or they'll
we
waive
help the family.
Or they'll waive their fees.
Yeah. And they'll I think that's when you see that, because we're in this hopefully for the right reason.
But when you bring the case in, you are well aware that the lawyer has to earn a fee, no problem. But it's how much work did he or she put into it? And sometimes they put a lot of work in, sometimes they didn't. So we are cognizant of that.
I wanted to jump
At least
back
I am.
really quickly, because you asked me about smell test, and right.
Yes.
I don't know. Okay, well, I don't remember the two really off the top of my head. But anyway, I just wanted to be very clear because when we're dealing with the money and other people. As an ad litem, I typically ask the lawyers to send me the medical records, the medical bills for everybody that's been involved in this case so that I can compare if it's apples to apples or apples to oranges. So you have to be informed, because if you want me to be on board with the allocation, you need to give me all the tools that I need in the toolbox to make sure that I'm like, okay, well, judge, this is why, right? And so if your ad litem is not doing those things, and I'm going to tell you in certain judges' courtrooms, that is not going to be satisfactory behavior. You need to know everything about the case. The more you know is really, it's better. The less you know and the less prepared you are, the likelihood of you being an ad litem in that courtroom again is very slim.
Can we have that shooting star above her
I know.
head? The more you know.
Yeah. The more you grab.
So you have to inventory past medical, and
Yep.
you got to consider, okay, this is a build rate, and this is an LOP issue. There's an uninsured situation that's deferred. I know it's going to be. You can do that kind of calculus and make a determination. What about a really bad case with a life care plan? Do you look at it, is this a litigation tool where it's $8 million, but I think it's closer to $2 million? I mean, you've got that freedom and flexibility, I guess, is your charge for the minor?
Yeah, but more importantly, I need to meet with the next friend and minor to find out what their current state is, right? If they,
Right.
and we're kind of getting into a different territory, but I mean, there's all kinds of things that you need to consider, especially when we have futures, right? Like whether or not this person's going to need care, and whether or not we're looking at a special needs trust. And so again, not all guardian ad litem appointments are equal. I mean, I've had the full gamut of stuff. So from the very simple to the very, very complicated. I've done several special needs trusts for incapacitated adults and for minors. So I just think it's, like I said, you need to be prepared. You need to prepare yourself to have the full picture. The last thing you want to do is go in front of a minor settlement hearing, and we've all heard this term, oh, I just had a minor settlement hearing that blew up. We hate that, right? Nobody wants that.
Yeah.
Now, going back with what Cheryl's saying about these difficult cases with the trust and the annuities and so forth, if you don't know what you're doing, you shouldn't do it. Bottom line.
How can somebody just getting started learn about annuities and structures and all of that?
Go shadow somebody.
Yes.
If you want to be an ad litem, go to an ad litem, go to a minor settlement hearing. Talk to people who do it regularly, right? Don't take on these appointments unless you feel comfortable and confident to do so, but more importantly, unless you're willing to reach out to others to learn, right? Because
You can't imagine the number of times you're down at the courthouse and they're talking about annuities and you're sitting in the back, I'm sitting in the back, and I'm listening to the guardian ad litem, and I'm like, no, that's not right. And the judge is looking going, well, let's table this for some other day. At that point, you actually know that guardian ad litem hasn't done his or her work.
Well, I'll just give you, I know we weren't really going to talk about war stories, but here's one for you. When I was a defense counsel many years ago, I had an ad litem that wanted to put $50,000 in the registry of the court. High, red flag, you don't do that for like a 6-year-old.
Right.
Oh, wow.
Right.
Yeah.
Well, that voids the annuity, right?
No.
There is no annuity.
There is no
Yeah.
annuity.
That's what I meant.
Yeah.
Like,
Yeah,
it is
there is-
impossible
yeah.
to get an annuity.
I was like,
if the
yeah,
bonds
the
are
judge isn't
benefits.
going to
Right.
approve this, like, let you know.
Correct.
But hey, if you want to go have your minor settlement and talk to the judge about that, I mean, you go fall on the sword, but that ain't my deal.
Do you have, I've dealt with a lot of ad litems recently, and, one of them was like, all right, if it's above 7,500, it's going to an annuity.
I don't even think you can get an annuity unless it's at least 10 grand.
Is it?
It used
Yeah.
to be. The cutoff was 8. Now it's
Yeah.
10.
Okay,
Yeah.
so yeah, he told us, I think it was one minor was getting 10 and one minor was getting 5 or
Yeah.
something. It was something
Yeah.
on.
Well, what you could do is if the two minors are related and it stems from the same accident, you can actually get an annuity and combine them, and so you meet the requirement. I forget what the terminology
If
is.
there are multiple minors,
Yes.
are there multiple ad litems?
It depends,
Sometimes.
right? Sometimes you have the same parents for the same kids, or you have different parents with different kids, and so then the court will ask you, well, Ms. Gilbert, was there a necessity to have a different ad litem? Well, no, Judge, because I have mom and dad who have 4 kids, right? Same household.
Yeah.
But if I've got mom and dad with 2 kids and mom and dad with 2 kids, then I'm like, well, why is Susie Sue getting more than Tommy or whatever the case? I mean, so you've got like parents fighting because their kid got less than the other person's kid, right? So in that situation, I've always found that it's better to have 2 ad litems because you got 2 sets of parents and 2 different children.
Like a bus crash.
Right, bus crash. That's
have
a primary
multiple
example,
people.
right? Multiple, right?
What on the annuity issue, just real quick, do you guys have a say in, I mean, you said you can't give advice and you won't give advice, you're not a financial planner, but things like, I mean, they can't factor, a minor can't have their annuity factored like an adult can, I assume. Right?
What do you mean by
do you mean?
factor?
Someone buys it.
I thought a minor could for some reason, but maybe when they turn 18 is when they
I'd
can.
hope not.
You're talking about the predatory people who
here's the-
contact you when you turn 18. Yes.
Certain companies that place life policies into structure, and the other side of the house is a factoring company just waiting to buy it.
And they do. And there's nothing we can do. I mean, that was my big issue back. I mean, I've been doing such a long period of time. I hated going into the courtroom and going up and listening to these people saying, well, you're going to factor out you'll get 70,000. But today, I can pay you 20.
Right. They're predatory.
And, they are predatory.
So some of the good judges, though, I'm sorry to interrupt you, but some of the good judges will tell the parents when they come down for a minor settlement hearing, you understand this money is going into annuity. I want to prepare you because your son or daughter at the age of 18, they're probably going to get some phone calls from some company saying, I can give you such and such money right now and you don't have to wait for them. Please educate your children, and or when you come down here to ask me to, or what is it, approve the release of the annuity. I don't know what the terminology is. I'm gonna make sure that they understand that this is not a good deal, right? So
going back to about annuities and what we can do. At the end of the day, it is the decision of the mother or the father.
Mother or father.
So we can do whatever we want to do, but if they don't want the annuity, we can't force them. We can't force anybody to get an annuity. We can show them the good things and bad things, but it's the decision up to the parents. Sometimes the parents get to a point, no, I want my kid to have 40, 50. I had one the other day that it was a large settlement, and the kid was going to get a certain amount for college. We set up a college program for her, and then she was going to get 20, X amount of money at 25, X amount, and so forth. Mom said, no, I don't want that. My kid was 10 years old. I think my kid needs to get the full amount at the age of 18, and that was a lot of money. Sitting back, and I'm talking to the plaintiff's lawyer, and saying, yeah, the mom wants the money. At the end of the day, the mom thinks she can control the money later on, but we can't do anything about that. Yeah. We're even in front of a judge. The judge will ask, well, you know that the annuity is a good thing for the child. No, I know my child. I know what I need for my child, and it's only me. Yeah.
Y'all gonna say in the percentage, like what goes into the annuity? Well, you would, because it all goes into
It all goes,
It all goes.
Unless some money is carved. I've had situations where we have trusts and annuities, flow together.
Because it's got to pay out until they're 18.
Correct.
Yes.
In very, very complicated cases, very high dollar settlements. What I wanted to talk about, and I think you kind of asked this, is, and maybe I misunderstood. Do you have a choice in who you use? Did you get to that question?
Well, I mean, I did, but I was curious. There's people in town that we absolutely trust. They're going to be in both on the defense side and the plaintiff side.
Yeah.
But I know as a former defense lawyer, I would see some structures that I knew the company had a factoring agency.
Right.
And I knew that the second it was placed, here we go. And I think that's probably too wonky for an ad litem to be able to dive that deep into the, underwriting philosophy of a life company. You can't do that.
I'm not doing that.
You can't do that.
I can't.
Because
that's
you would
outside of the
actually
bounds.
expose yourself
Yes,
to
that's
further
correct.
obligations.
Yes.
But from an allocation standpoint, you guys can just say, look, you co-brokered more likely than not. These folks will give you the right guidance, and as long as you know the cash number's right, but you don't concern yourself with a payout because you can't.
Let me try to answer the question, and at least this is my practice. What I typically do is there are people in town that I use, and when I have resistance from a next of friend, what I'll do is I'll bring that person in to help me, okay? And I'll tell you why, because when you start talking about benefits, government benefits that people get, right? That
Medicare and Medicaid. I'm sorry.
Medicaid, yes, any kind of income will affect, right, your benefits. This is not an area that I know. I am simply an attorney, and my wheelhouse is PI, but I'm not, a financial advisor, and I'm not versed on how things affect and cross-pollinate or whatever. So I bring in people to talk to the parents about how putting this money into a trust does not affect your benefits, right? Your Medicaid benefits or your stipends that you get on a monthly basis. When we're talking about annuities for parents, what I bring these professionals in, I know we've used names, but I'm not going to use names, but the people that I trust to use for annuities, I have them explain how this money is tax-free, right? I explain how this money is set up so that it's based for a college plan, and then you get lump sums, and why this is important, and why the money grows, and why it's more important to wait it out as opposed to get the money at 18, right? Let the money work for itself. And so I kind of put that onus on the professional, and so that alleviates me from that sort of financial conflict. Then they can hear it from the horse's mouth.
Right.
They almost get like a financial planner sort of consultation, and then they feel like, okay, well, this ad litem, I mean, at least she knows what she's doing, one, but two, she's got the tools in her toolbox to tell me why I should do this for my child, right?
Those professionals are very important.
They're very important.
Yeah. And they're phenomenal. You know,
They are.
Yeah, I was about to say, I think Omar can attest. Kherkher Garcia, we do that all the time.
Yeah.
We highly recommend clients get annuities and structure some money, and we let the professionals be the one to tell the clients the pros and the cons. We simply just facilitate the meeting.
And I think people appreciate that because they appreciate hearing from someone else that's not an appointed person by the court, but has the tools and the resources to get you through the professional to explain further, right?
Well, and we're getting very into the weeds here, which I love. But just on
the show.
The high level, just for some of those that haven't maybe got to this point where they've had a minor, so the minor can't take the money. That's always been the case, and the two options usually are going to the registry of the court, which doesn't bear any interest.
It does. It's very nominal.
Very nominal.
Very nominal.
Or go into what we call structures, annuities, where you have these advisors, companies like Sage or Robin Young, and we can, these are people we know and trust. And
good plug.
Yeah, I mean, I love them both. I really do. And so they help you out so much by investing this money. You get, tax-free, but there's so many little nuances, like putting it in the release. So these are things that you need to get involved in early. When you know the case is getting ripe to settle, start bringing these people in and put them into these vehicles that will help. And so I'm just putting that in the high level. And the high level, what we're talking about here, because some people don't know about it. I didn't know about structures and annuities until we had that right case that had to go get structured or put an annuity.
Yeah, echoing, I think that's really important because a lot of people listening might not have ever been in that situation, but effectively, this is way over generalized statement, but if the settlement funds ever hit a plaintiff's attorney IOLTA, it's too late.
Correct.
Yeah.
You need to be proactive. You need to do this before the
Way
settlement
before
happens.
that.
So it's not I have the check right here. Let's go call Sage.
Yeah.
You're too late.
Right.
I want to switch a little bit because my brain is kind of jumping around, but I want to talk about lawyers who release funds before a minor settlement. And so
To the adults?
Yes.
Are you talking about? Okay.
So because we have
If
lawyers.
it's not approved yet, you might have to claw some of that back.
Right.
That happens quite often.
It happens so much. I have so many appointments right now where the money for the child has already been given to the parent.
Yeah, and clients love giving money back.
Yeah, and now the lawyers are having to pay it. So it's become a really big issue, and so don't do that if you're out there practicing law, and you don't want to pay out of your own pocket. But I think really and truly that falls on the defense too. You shouldn't be giving the money.
It falls on both.
It falls
Defense
on
and
both.
plaintiff.
It's like both hands are guilty, right?
Get that
They
judgment
can't.
signed
They have to
before the bride.
send. They would have to fund the structure by sending the check directly to the structure company or the annuity issuer, but the cash portion, fees and whatnot, would just go to the plaintiff's lawyer.
But that goes back to the original question about how soon should we have the hearing, the ad litem?
Yeah.
It's as quick as possible. I mean, once you get the appointment, and I'm going back to earlier, once I get the appointment, my druthers, my secretary calls the court up. When's the first available hearing date? If the hearing date is within a month, set it up that day. The problem I've got with a lot of plaintiffs' lawyers is they don't present the evidence. They don't give us enough information. They don't give us the medical bills.
Drag their feet.
They drag their feet.
They're still negotiating the lien.
Right. They're still trying to negotiate. I try to get the date within probably a month because that should give enough time, for at least 4 weeks, to get people together. During that 4-week period or during that 5-week period, you got an adult saying, hey, I need my money.
Yeah, they're calling you.
And so now
Where's
I
my
need
money?
a loan. I need a loan. I need the money. I need a loan. And so then you have loans coming in. Then you got some extra fees. And one of the problems I have with some plaintiffs' lawyers is they have in their expenses when they're trying to get the money out for the minor, in the expenses they put the loans in there. You can't loan money off a child's settlement, and you have that. Believe it or not, it's real simple, right? It sounds real simple, but a lot of plaintiffs' lawyers try to put loans on the minor settlement checks, on the minor settlement funds.
I don't understand.
What they do is they take money out. They
You know,
loan
I'm
the
new to
parents.
this side here, so
was
I'm very
like,
curious.
okay.
Yeah.
What?
They take money out and they loan the parents money. They loan the kid, and they try to allocate it
or
and,
proportionate.
and they try to put it in as an expense for the minor. Well, you can't do that.
And you scrutinize expenses.
Oh, yeah.
Oh yeah.
I always ask for a detailed expense report
Yes.
because I'm going to tell you right now, if your expenses aren't pro rata share, I'm going to have a problem with that.
And
right?
even I have a problem sometimes with pro rata share.
Yeah.
It depends on the case. I look at the expenses, and especially when you have an expense, and some plaintiffs' firms have an automatic expense of $500. What's $500? It's just a case fee. What's that? What's the case fee? It's what we charge every file.
Well, you're
not
gonna
gonna
get attorney's fees.
You're not going to charge this file a case fee.
Didn't know these things exist.
Oh yeah.
Yeah.
And
Come on, Will.
So I think a large purpose of why we wanted to have this conversation is because it's important to always keep in mind that the parents' claims are individual, and then we have the minor's claims. So I'm going to let Will, because this is a hot topic right now.
Well, yeah. I mean, as a defense lawyer, I knew there were cases I had where someone filed a claim as next friend, did not sue in their individual capacity. 2 years comes and goes, and then the medical bills go poof.
Bye-bye.
Because the medical bills, because the kid can't contract, are owned by the parents, so the 2-year statute applies.
Correct.
And there's a lot of mistakes made, either not pleading it right or who gets it. I mean, not just in your world, ERISA liens and everything else.
Right.
And I know there was a recent case that came out that we're not necessarily going to talk about because it's pending on appeal, and we don't want to give any insight with two professionals that could guide anything, but it's an issue, is it not?
It is an
Yep.
issue, and it's an issue that everybody has an opinion about. But I would agree with that same sentiment. I don't think it's final, but what I do think is important for people that need to know, especially if you have a case that is going to be a minor prove-up or friendly suit, and if you're thinking about doing ad litem work, is that the medical expenses, that is a claim that belongs to the parents, right? And so you need to make sure that you are pleading and that your active pleadings at the time of the hearing, the prove-up, includes the individual claims.
For the parents.
For the
So
parents.
it needs
On the
to be
medicals.
styled parent individually and as next friend of minor.
Correct.
9 times out of 10, that's the way it's styled.
Correct.
And do you need both parents?
No.
Not necessarily,
Okay.
no.
Some judges do require both. I know Montgomery County did at one time. They required both parents to be online, but I don't think they do that anymore.
That's good.
Yeah.
And what are your thoughts about the minor coming to the minor prove-up?
I personally, if the minor really doesn't need to be there, I don't want them to miss school. I really don't. During the summer, I say come on down. It's a great experience for the kids to come on down there.
Right.
Some of the judges do require them,
Same.
and the problem I got with some of these judges requiring these kids to come down, they got to miss school.
Yeah.
And especially if it's a soft tissue, there's no scarring, anything like that, they really don't need to come down. My job as a guardian ad litem, or our job as a guardian ad litem, is to visit with a child. We visit with a parent and we visit with the child. We also make the determination whether or not the child has to be down there.
We're the eyes and ears of the court.
Right.
And I think that it depends on the case. It's case specific. If the minor does have physical disfigurement and or scarring, the judge may want to see that,
Yes.
right? And so as much as my word is good, the judge may want to go an extra step. But again, we sometimes don't have control of that situation because a lot of judges are like, I want the minor here.
Mm-hmm.
And I mean, we have so many district court and county court judges. You've got to know your judge. And that's the other thing is if you're going to be an ad litem, you really need to know what the judges want. It's going to be every court's going to be different, and everyone's going to require you to do different things. So you need to be prepared and know that.
And even if we approve the settlement for the minor, the judge still has to approve it. So
Yep.
it doesn't necessarily mean that it's carte blanche. Once we've done it, the judge has to review it.
Have you ever had a situation where you approved a settlement, the judge?
Oh yeah.
Yeah.
Oh yes. Yeah. I've had those times, and I'm sitting back going, why? I had one judge not approve it, and I afterwards I was scratching my head going, why? Why wouldn't approve it? And I we had a status conference there shortly thereafter. Judge, you understand that this minor will turn 18 in about 4 months. At 18 years old, these guys are going to pull the money off the table, bottom line. So, we're going to approve the settlement, or this money's off the table and this minor's not getting any money. So the judge signed the judgment because they weren't going to pay any more money.
Do you know why the judge didn't want to do it?
Because he just didn't think it was enough money. That's all, bottom line.
I've had cases where
They're not going to tell you in that status conference why. He just says it's just not enough money.
I've had cases where judges have opinions about specific medical providers or I'll just throw it out there, LOP providers for kids, whether or not certain care is really care. Why didn't the kid go to a medical doctor? Right? Why did they go to a chiropractor only? Did they go to a primary care physician? And so they get very inquisitive, they get very involved, and so sometimes they don't think that the settlement's enough, or they don't think that certain providers should be paid back.
But our focus is always on the best interest of the child.
Yes.
What is the best interest of the minor? What is the best settlement for the minor at the end of the day? If you don't pay the medical bills on some of these cases, well, I'm not going to go there. Never mind.
But every case involves some.
We'll revisit it shortly.
Yeah.
But every case involves some risk, and that's one of the questions we ask. You could go and get nothing. I mean, I don't see a jury not being sympathetic to a minor child, but it can happen.
It can happen.
There's a lot of factors, but that's the main question: is it in the best interest of the child?
Right.
And someone else is in there to determine that as a third party.
Especially in liability disputes, for example, right? If you try a case and even if there's a minor and there's some sympathy, the facts are the facts, right? And if a jury doesn't find, the defendant negligent and you don't recover, then, there is no recovery for the minor. No.
But even if
Shout
you go...
out Shane Osborne.
What?
I said just shout out Shane Osborne.
But even if you go to a trial on a minor, at that point, the minor bears the attorney's fees, full 40%. The minor also bears the expenses, the expert fees that are down there. Yeah. There's extra fees that are there that the minor really shouldn't have to bear.
Yeah.
Y'all had situations where the minor settled, but their parents didn't? That other cases
I've had
tried?
that too. Yeah. And more specifically in liability disputes.
Right.
And so, especially when you have the liability on the parent, right? And so you can get into a pretty dark, tangled web in the ad litem world. You really got to use your legal gymnastic skills because there are some complicated cases.
Yeah, I had it when I had primary, wanted to dump a limit in excess, obviously had an obligation to defend at that point. It's like, well, they'll just buy the kid's claim off.
Right.
And it happened, not often, but happened.
Yeah. Back in the day, we used to be able to do, I had a case where the parents wanted to use the children at trial, just basically use them at trial as pawns because they thought they'd get more money. I said, no, I wanted to get the case, this before the rules changed. I said, no, this is this, you're going to get this and this and this for each of the kids. That's all they were going to get. It was a soft tissue injury claim. They didn't need to go to trial. They wanted to go to trial. I said, no. So at that point, of course, they didn't like it. They wanted me... they wanted to be struck as an ad litem because they thought I was trying to take the case over. At that time, we could take the cases over. We could settle the cases from under the parents. Fortunately, the judge found in our favor and settled the case. But nowadays, I don't think we can do that. I don't think as a guardian ad litem, I can come over and say that I can take the case away from the parent. Nowadays, we can go in front of a judge. The defendant can say, Judge, we have a settlement right here. We think it's a good settlement. What's the guardian ad litem say? Well, Judge, we think it's a good settlement. The parent doesn't want to settle it, though.
I have a current case where the policy limits has been tendered and they haven't accepted, and they're going to trial. Yeah. So, yeah.
But it depends on the parent. Now, remember, we can approve it. We can approve the settlement. The parent still has to say yay or nay.
Because they had to sign off.
They have to sign off on the judgment, also on the release. And the judge also, the judge has to sign off on the judgment, but the parent doesn't want to do it. The parent doesn't want to do it.
Tell me real quick, you talked about it right at the beginning, and I will concede my naivete. I don't know what goes into the decision of a special needs trust and how it works. I've had cases, obviously, with special needs trusts, but I didn't know the behind the scenes, like, this is why we need to do it. It just kind of happened. Because frankly, once I settled a case, I was gone. I was doing the next one.
Sure. And so there's all kinds of scenarios. The ones that
No, go ahead.
Well, the ones that I've had recently, it's where the child needs additional medical care and additional expenses. It's basically like an opportunity for the guardian to have some sort of resources to care for the child related to the accident. So, for example, if the child needs to have psychiatric therapy, right, then some of that money would be used for future care related to that because it stems from the car accident or whatever the case may be. In another scenario, I had a special needs trust because the child was autistic. And so there was no point in putting that money into an annuity because even when the annuity matured, they wouldn't be of sound mind, right, to have to spend that money or know what to do with it. So you put it into a special needs trust so that the trustee, you have to go and ask for permission to withdraw the money and the reasons why. And there's all kinds of parameters. And our friends over at Sage and Robin, for example, or other people who are versed in that area can tell you the guidelines for that. And there's all kinds of various brokers for trusts, and I've used Legacy Healthcare or Legacy Community, I can't remember the name specifically, and there's lots of nonprofits in the state of Texas that have a trust pool. But I'm not versed enough as a financial advisor or in that area to know what the reasoning is to ask for the money. I just know in what scenarios as an ad litem that I've used it, and it's been in those particular
and
scenarios.
we're going to do a show actually with someone that is able to explain this in detail because it is important. I have one with a adult 35 with Down syndrome,
right,
and she can't get the money because I always get Medicaid.
Yes.
So they have to do a special needs trust, a pool trust, but they teach you all that. But that's where the ad litem comes and helps me, and we can all kind of group together, and then you kind of ship it off to let someone with expertise do it.
Yeah, these advisors are great. I mean, you sit with them, they'll tell you the good things and bad things and what you do on the trust and where Medicaid is involved or where Medicaid isn't involved. Because there's certain points that if they get a certain amount of money, Medicaid's cut off.
Correct. They lose their benefits.
They lose the benefits. And
Which
we
is
don't
awful.
want them to lose their benefits. We want to keep the benefits, but we also want them to get the money from the settlement.
Yeah.
Well, you mentioned shadowing you. Both you folks are kind enough for the people watching, if they're a younger lawyer that want us to get experience with obviously probably lesser value cases, they can, when you said ghost you, like they can literally follow you around and come to your office.
I think ghost you does not mean follow you around.
I think that's
he's
weird.
too old.
Yeah.
It's like, I think ghost means
ghosted. It does now, but back then,
I was like, I don't think
Gen
that's what that
Xers use it
means.
differently. Yeah.
Shadow, I think
Shadow,
is what
that's
the
what
word
you
you were
said.
looking for.
Yeah.
Either way, it's scary, right?
Yeah.
Shadow.
Now, people want to call us and shout. I'm more than open. I've always been open. I've always told everybody, if you want to come take a look at what we do as far as guardian ad litems, come on over. I've got, like I said before, I've got this 2 or 3 page questionnaire that you can ask. We don't use questionnaires because we
do these. I can do these in my sleep.
every single day. But we're available if people want to do that.
I would just also go say, and I used to do this as a young lawyer, go park yourself at the courthouse on a Monday.
Yep.
And like starting at 9 o'clock in certain courtrooms, you're going to see a bunch of minor prove-ups. And just go see. There's all kinds of different styles. You'll see who's doing the prove-ups. You'll see whether or not it flows easily. You'll see if the judges start asking a lot of questions, it's probably because you have some problems on your file. A recommendation that I make is make sure all your closing documents are on file with the court. Don't be fumbling around. You want to make sure that the judge has the judgment well in advance. You want to make sure that your appointee fee is filed well in advance. You don't want to give a reason for the judge to not approve the hearing. And so, like even as a defense attorney, when I was doing defense work, the worst case scenario is everybody goes down to the courthouse to be told, okay, this is not going to be approved. This just blew up. And now you got to go back to the drawing board. So I think that's the most important thing is to avoid that. And then I will tell you that a lot of the judges at the courthouse are making sure that you've met with the parent, but you've met with the freaking kid too. I mean, that's super important. If you laid eyes on the kid, if the kid is of age to have a conversation, especially if a kid's like 13, tell me where you want to go to college. What do you want to do with the money, right? Do you understand what's happening happening to your money?
I
And
love
so
the parent that's always like, they're not the college type. We don't need to do that. But I was like,
right.
He's,
He'll be
he's
older.
10.
Yeah.
Like,
Yeah.
give him a chance.
But the important part about that, you got to know your judge.
Yeah.
You got to know what the judge wants. Each of these judges, we have how many? 27 at the courthouse?
Got a lot.
Yeah, and we have four
more coming in, right?
We have 4 county courts. You have to know what the judge wants because each of these judges have a very different perception as to what they want in guardian ad litems. Some will just sign off on it, and some will go into detail. Well, what about this number here? What about this? What about this? Have you tried this? Does he have a headache? Does he need more psychiatric care? I've had judges before where you're sitting there and the accident happened 3 or 4 years ago. I think they need more psychiatric care. Well, Judge, you haven't seen a doctor in over 3 years. Yeah, but I think they do. So you got to know your judge.
One thing and I'll end it on this. One thing I want the audience to know is that if you're a plaintiff attorney, you need to tell your client why the ad litem is contacting you.
Oh, please. Yeah,
There are so many
Yes.
times that my office will send an email or a call and they're like, well, who are you? Or I'll meet with these people and they're like, did your lawyer tell you anything? Did you know we have a hearing scheduled on such and such day? Do you even know how much money your child is getting at the end of the day? Do you even know what your case is settled for?
And that's important because a lot of times when we come in and the plaintiff's lawyer hasn't prepared the client, they're afraid.
Oh,
they
yeah.
think we're there to because we're legal, and they're afraid we're here to tear down the settlement or find them at fault or something. No, we're here we're a friend of the court.
Well, yeah, thank you guys. This
Jose,
was super.
Shara, thank you for coming on.
Yeah, this was super informative, and yeah, I hope it helps everybody listening. But it's always good to be on that side, and you know, we didn't get to talk about it as much, but these are 2 phenomenal mediators that are very busy, but it also helps them value and whether these are in the best interest of the child because they've seen the value. They get these cases resolved and they know what cases are going for. So they are phenomenal ad litems, but great lawyers, great mediators.
And thank you for the invitation.
Yes, thank you for
And a
having
quick
us.
plug to book mediations at Jose Lopez. You have a website, I assume.
Jose or Lopez II.
There you go.
But the second, not the
Gilbert?
third.
Yes.
thegilbertlaw.com. Yeah. So I have an
Well, thank you.
online booking calendar, and I think I'm booking in December. I'm sorry.
Yeah, you can go into 2026 with Shara if you want to go
Yeah.
mediate.
It's pretty busy.
Schedule mediation for a case you haven't signed up yet.
If you filed an answer, you might want to get on the calendar now.
Yeah.
Thank you.
Thanks, guys.
Thank you so
Thank you guys
much.
very much.
Yeah.